Welcome to The Debate. Today, we are diving into, well, arguably the most profound digital transformation of law occurring anywhere globally. The deep integration of artificial intelligence and surveillance technology into every single stage of China's criminal justice system. We're talking from the initial police interaction right through to the final court judgment.
It really is unprecedented in scope, isn't it? I mean, you're looking at these vast infrastructure projects like Skynet, the police cloud. It fundamentally reorients the entire relationship between the state and the citizen.
Precisely. And this massive technological push forces us to ask a really critical question. Does the Chinese government's, let's say, aggressive deployment of these data-rich public security contracts primarily function as a powerful industrial policy? One that drives beneficial AI innovation and quantifiable judicial efficiency across both public and commercial sectors.
Or, conversely, and this is where I tend to focus, do the inherent governance risks, the really profound ethical compromises required by the system of, frankly, mandatory hypersurveillance, do they fundamentally undermine the rule of law and maybe even the trajectory of ethical technological development in itself?
Right. So, my position is that the strategic state approach has generated tangible, verifiable gains. I want to focus on the resulting efficiency, the standardization of judicial outcomes, and importantly, the significant economic benefits that come from this targeted AI industrial policy and the technological spillover.
And I approach this dilemma more from the perspective of risk and, I suppose, integrity. While, yes, measurable speed improvements might be there, I maintain that the systemic erosion of individual rights, which is caused by this mandatory data fusion, and the resulting compromise to judicial independence, well, they significantly outweigh any purported gains in efficiency.
Okay, let's zero in on judicial throughput for a moment, because the evidence for efficiency, I think, is compelling. The state has uniquely leveraged its mandatory demand power to rapidly innovate these judicial systems. Consider the Hainan High People's Court. After they implemented AI assistance, the time required to produce final judgments dropped by over 50%. Written judgments, they required 70% less time. And maybe most crucially, procedural documents, which are the bulk of the administrative labor, right? They saw a stunning 90% reduction in drafting time.
Those are certainly stunning metrics for administrative speed, I absolutely agree. But focusing purely on speed and volume kind of ignores the strategic resource allocation, doesn't it? Or these judges now spending 90% more time on, say, complex legal interpretation and really digging into evidence review? Or are they perhaps simply signing off more quickly on pre-vetted AI recommendations? Speed doesn't automatically translate into better quality justice.
But that's exactly where the quality argument comes in, I'd argue. This standardization mechanism is designed to enhance consistency and fairness. Take the Intelligent Auxiliary System of Criminal Case Handling, or the 206 system as it's known. This system was explicitly designed to combat those historical issues of weak or even illegal evidence, and to reduce the variance in decisions among different judicial personnel. So this isn't just about faster word processing, it's about managing consistency.
I acknowledge the internal goal of consistency, sure. But that consistency requires a scale of data fusion that, in effect, creates an omnipresent surveillance state. The state is clearly prioritizing predictive control over individual rights and procedural fairness, and the data scale involved is just staggering. You mentioned the police cloud in Zhejiang province. That alone apparently contains over 1.6 trillion data points.
Well, that's robust infrastructure, isn't it? It's arguably necessary for maintaining public order, especially in dense urban environments.
Or it's infrastructure for ubiquitous, pervasive control. We have undeniable examples where these predictive analytic systems, like the Integrated Joint Operations Platform, the IJOP system, used in places like Xinjiang, automatically flag individuals as suspicious. And I mean, based on really mundane behavioral data, like using a VPN, or maybe having what the system deems an unusual amount of fuel. These algorithmic alerts can lead directly to detentions. That demonstrates algorithmic presumption replacing due process before a case even gets near the formal court system.
While the public security apparatus is undeniably data-intensive, the formal judicial system, it's important to note, retains human oversight. And the 206 system you mentioned, it's built upon massive, authoritative judicial data. We're talking 320 million pieces of legal information in the National Judicial AI platform, specifically to standardize evidence checks and recommend sentences. This scale aims to rationalize justice, make it more predictable.
And yet, while guidance does exist, like those Supreme People's Court opinions from 2022, which do emphasize human decision-making rights, this guidance remains fundamentally a policy guideline. It's not enforceable regulation. The legal safeguards are lagging, I'd say dangerously, behind the technological capability, especially when you consider data collected under, say, emergency powers, like the health code system during the pandemic, is then reportedly reused for ongoing surveillance and social control. That really blurs the boundaries of legitimate state intrusion.
This brings us directly to the core tension, doesn't it? The necessity of the data environment itself. You frame the requirement for massive data access as a risk. I frame it as the engine of superior technological progress, the key ingredient for effective industrial policy. The necessity of high-quality, large-scale data collection, particularly through things like high-resolution facial recognition contracts, acts as a uniquely potent industrial driver.
Powerful? Yes, I'll grant you that. But explain to me how this public surveillance demand actually yields generalized commercial benefit. Why does the requirement for what is essentially involuntary data collection make the resulting technology better for the wider commercial market?
It's because of the technical requirements embedded within the contracts themselves. The state requires exceptionally high standards for data cleanliness, for throughput, for accuracy, often in very challenging real-world environments. This provides AI firms with a superior, large-scale training environment that they might not otherwise have access to. And the research seems to confirm this spillover effect. AI firms that receive these data-rich public security contracts, specifically those operating in high surveillance prefectures, show a significant differential increase in their subsequent production of both government software and generalized commercial software.
So basically, the high standards required for state surveillance provide a kind of subsidized R&D platform?
Exactly. They can then leverage the resulting expertise and the model training at minimal additional cost to develop broad commercial applications. This demonstrates clear economies of scope and, well, generalized market technological transfer. Public demand for sophisticated AI tools demonstrably pushes the overall market forward.
But the fundamental flaw in that line of reasoning, I think, is the assumption that the market being pushed forward by public demand for surveillance is somehow a neutral good. That data-rich environment you describe is built on involuntary compliance. It creates an ethical distortion right in the tech ecosystem itself. I mean, the key infrastructure providers, companies like Hikvision, Megvii, Dahua, these are companies deeply implicated in human rights concerns. By channeling massive state resources into these kinds of contracts, you force the entire innovation trajectory to serve state control mechanisms rather than, say, open societal benefit. The market incentive itself becomes warped.
But let's return to the courts for a moment, where the stated goal is consistency in the application of law, irrespective perhaps of the initial data source. Even if the data acquisition methods are subject to debate, the application within the courts can still promote procedural justice. The 206 system, for instance, explicitly targets those recognized major causes of incorrectly decided criminal cases, things like inadequate evidence examination and significant differences among judges. These systems aim to reduce human fallibility and promote procedural justice.
But the standardization, it arguably comes at the expense of necessary judicial discretion. Systems like Little Judge Bow, they may only recommend sentences, and judges formally retain the liberty to disregard the suggestion. That's affirmed by the Supreme People's Court policy. Yes, that's the formal argument. But we really have to discuss the functional pressure this introduces.
Well, surely a judge is the final arbiter of law. Their professional integrity should allow them to disregard the AI suggestion if the specific facts and nuances of the case demand it.
That assumes a system built fundamentally on judicial independence, not one increasingly geared towards managerial efficiency. Let's consider the actual mechanism of control here. The Jiangsu High People's Court, for example, operates an AI warning platform. It automatically triggers an alert if the calculated deviation ratio between the AI's predicted sentence and the judge's actual proposed sentence exceeds a certain fixed threshold.
Which sounds like a quality control mechanism.
Or it's a profound limitation on judicial independence and practice. When an AI system, designed specifically to solve incorrectly decided cases, warns a judge that their ruling falls outside the algorithmic norm, what's the likely professional incentive? Especially in a system that's prioritizing throughput and efficiency metrics. Which judge is likely to risk triggering a high court flag, which might require extensive justification, slow down their output? The technology seems explicitly designed to manufacture compliance pressure, regardless of the formal policy that says they retain discretion.
Okay, but the regulatory framework isn't static. It is evolving to meet these challenges. That indicates, I think, an internal drive toward accountability. We saw this demonstrated just recently. In 2025, the Xiamen Maritime Court issued what seems like a landmark ruling. It requires lawyers to disclose the full use of AI in civil proceedings, things like tool specifications, usage parameters, even the verification methodologies they used.
That civil ruling, while certainly a positive step for transparency, applies to things like contract disputes, doesn't it? Not criminal matters where life and liberty are actually at stake. And as of, the latest information around August 2025, specific national legislation expressly governing AI use in criminal proceedings simply doesn't exist. We're still relying on that non-enforceable policy guidance.
But the focus on transparency, this idea of making the underlying logic of assisting judicial presumptions open to examination, that's a critical, evolving safeguard. It seems inevitable that it will influence criminal practice over time.
That assumes transparency is even technically possible in these systems. How can a lawyer effectively challenge a judicial presumption when the underlying logic is embedded within a massive, proprietary large model AI, like, say, DeepSeek? The sheer complexity combined with commercial secrecy means true examinability might be functionally impossible. And furthermore, the official ethical risk management system relies on conformity to core socialist values. That's a criterion far too vague and frankly politically charged to effectively guarantee fundamental rights protection against algorithmic overreach. It feels much more like an ideological safeguard than a robust legal one.
Look, I maintain that the material clearly shows the aggressive, data-driven approach has been, in many ways, a profoundly successful engine. It's driving efficiency and acting as a catalyst for technological advancement within China's AI sector. It has produced quantifiable judicial benefits and demonstrated significant market spillovers that I think cannot be dismissed simply by questioning the methods used to achieve the necessary data scale.
And I would conclude that while those efficiency gains and technological advancements are certainly evident, the very foundation of this success, which is mandatory, massive, and largely unregulated data fusion driven by public security agencies, introduces unacceptable systemic risks. This system leaves judicial independence deeply vulnerable to algorithmic control and potentially shifting political priorities. It fundamentally compromises the integrity of the rule of law as we understand it.
What seems undeniable, though, is the technical capacity China has engineered. They've managed to integrate AI into essentially every level of its criminal justice system.
Right. And the critical challenge remains for observers, both inside and outside China, determining whether those undisputed technological gains are ultimately worth the inherent ethical and societal cost of the mandatory hypersurveillance that seems required to fuel them.